for a great conference so far.
Good morning.
So the title of this presentation, WICWA and ICWA from the Bench, Learning from ICWA Courts. Washington State currently has nearly a ×3 American Indian Alaska Native disproportionality in foster care from the 2021 AFCARS. So this session will provide attendees the current effort of ICWA courts to capture the spirit and the letter of WICWA and ICWA law, as well as the unique perspectives of judicial leadership towards improved outcomes. ICWA courts aim to improve outcomes through tribal collaboration and cultural humility with Indian families. So we're looking forward to this panel discussion about gold standard practice, where ICWA courts have emerged as an intervention to work directly with American Indian, Alaska Native families in hopes of reducing disproportionality and improving the outcomes of our tribal youth in foster care. And ICWA court evaluation has evidenced the impact with earlier case closure and higher permanency outcomes with family for reunification and kinship guardianship. I don't want to say too much more because I know we have a lot of experts here, including Sheldon Spotted Elk, who actually reached out. Sheldon had presented here at our ICYF conference a few years ago. And because there's so much happening here in Washington State, Sheldon had reached out and specifically asked to take this time to be able to share with us and all of our attendees some of the great work that's happening. So before I hand it to Sheldon, who can share and have the others on the panel introduce themselves, I'll also say that Sheldon is an appellate judge for the Ute Indian tribe. So we have a pretty esteemed bench joining us today with him and his panel as well. Sheldon currently works as the Senior Director of Judicial and National Engagement for Casey Family Programs. So Sheldon, who graduated from the University of New Mexico School of Law and received a certificate in federal Indian law, is a member of the Northern Cheyenne tribe. And so thankful to have you here to ask to be on our agenda, who will also be joined by Commissioner Robert Porter of Yakima County Superior Court, Commissioner Ressa from the Spokane Superior Court, Commissioner Elizabeth Stanley, who was appointed as a family court commissioner in Clallam County Superior Court. So with that, I know that I don't want to take too much of your time, and I'm so excited to hand it over to you, Sheldon Spotted Elk.
Awesome. Thank you, Talina. I appreciate that so much. Appreciate your leadership here and making space for this important conversation. Hey, do you know what I'm going to tell you a little bit? What we're going to do is we're going to have a conversation. If this is done successfully, it's going to be like we're at a coffee shop and you're sitting at the table with us. We do want you to include you in the conversation. And so we'll have the chat open. And so to get used to the chat, I want everybody, since it's National Native American Heritage Month, I want you to write in the chat, who's your most inspiring Indigenous person that you know? Who's somebody that touched your life and an inspiring Indigenous person that you know? So put that in the chat, inspire all of us with some of these people that inspired you, whether they won gold medals or whether they parented you or whether they showed you love. So who are some Native people that inspired you in your life? So I want you to get used to using the chat. We're going to have a conversation about ICWA courts and their impact in the state of Washington. We have some great judicial leaders here. So we're really going to kind of highlight a lot of these things. Of course, judges ethically can't talk about active cases. And so if you do have a question for them and you might have a case before them, of course, they can't answer questions directly about a case, but you might want to ask maybe generalities about, hey, what are some good things that you've seen around documentation from tribal workers, or what are some great things that you like to see in reports, in tribes reports. So you could ask questions like that, most definitely. So please engage us. I'm so happy to see some of these names come in. So recognize some of them. So amazing. Thank you so much for sharing. I will tell you quickly what an ICWA court is. It's a really sticky idea. And so about 7 years ago, there was only 2 ICWA courts in the whole country. LA and Hennepin County, Minnesota. Duluth shortly thereafter got one. And now there's 22, including Commissioner Porter's, the latest and the greatest out in Yakima County that started an ICWA court. And so we're going to talk about their impact. Why have an ICWA court? I'll quickly give you one more context statement for this. Is about, I don't know, 6 years ago when we had only 5 ICWA courts. We brought them all to Denver and we had them all sit around tables. We had judges sit with judges, county attorneys sit with county attorneys. And we started talking about what makes ICWA courts an ICWA court. So 4 things kind of floated to the top about what makes ICWA courts an ICWA court, because of course, from all across the country, California might have a little bit different process than Washington does. And so we wanted to kind of get some similarities from the 10,000-foot view, so to speak. And so these 4 principles came to fore. And one, the first and foremost, is judicial leadership. So you need a judge, we need a hearing officer that's willing to step forward and show the type of leadership that includes hosting meetings, taking off the robe, so to speak, and getting off the bench and being inclusive in that way and driving mission-based practice. 2, willingness to collect data. Number 3, training. So everybody that practices in this court, when they say all rise, everybody in that room should know ICWA practice, both the letter and the spirit of the law. And then number 4, and this is the secret sauce, and we'll get into this a little bit more, but tribal engagement. And so how are you engaging tribes that appear most in your jurisdiction? We've included a 5th one since then. And so gold standard practice. And so we want gold standard lawyers. We want solution-oriented social workers. We want judges that are empathetic and compassionate. And so we'll have a conversation about what an ICWA court is and their impact in each of the jurisdictions. But to get to know our panel a little bit, I do have a question for you as a panelist, and we'll just kind of answer this question to start us all off and to get us warmed up. So of course, the journey to the bench, you've had other jobs, but why'd you end up doing child welfare work? How'd you end up doing and having this interest to take that extra step of saying, do it, I see a problem in my jurisdiction, or I want to improve practice with ICWA and WICWA compliance. And so what inspired you to take that step? And then secondly, I'll include to that question is, who's somebody in your life that inspired you to be compassionate and to work in the helping professions, if you will? So if it's all right, we'll start with Commissioner Ressas, and then we'll go to Commissioner Porter and then Commissioner Stanley, if that's okay.
Okay, good morning, and love seeing the squares of people I've not seen in a really long time. So good morning. And I'm sorry we can't do this in person. Hopefully again, we'll be able to meet at the Wolf Lodge or some other great place to have this conference again. I'm Michelle Ressa. I am one of the Superior Court Commissioners in Spokane County. I've been on this bench for about 16 and a half years, 17 and a half total. I was in Grant County for a year. I've always presided in our ICWA court since starting, well, since that court started in 2007. It started in January. I started in April. So other than those first 3.5 months, I've been it. That doesn't mean that there is not an enormous space still for improvement in the way we do things. And I'm taking some inspiration from some of the things Sheldon just said about leadership that I need to get back on track for. But the route to the bench is not often through juvenile or family court in the state of Washington. That's not typically how somebody either gets appointed by the governor or runs for an election. They've done other types of law work. I started my first law job in law school as an intern with the Attorney General's office doing child welfare. And that was in 1995. And that's what I have done since, is either worked for the Attorney General's office in the place of being the lawyer for the agency. I have some guilt and shame about some of the things that I advocated for and argued for during that time, and I can share some of that today. But it was an incredible experience to be a part of some ICWA cases, even though I'm not sure we always knew which ones those were. When I first became a judicial officer, I've had a dependency docket every week for the last 17 years. In Grant County, there wasn't a specialized court. I'm not sure if there's a working around that now, but in Spokane, when I was appointed to the ICWA court docket because nobody else wanted it. It was harder. It was going to be more challenging. You would have to learn more things. And not that people weren't interested in doing that, but I was the newest person and you got to pick and nobody picked. And I was the proud person who received it. And I'll tell you now, as the senior judicial officer on my bench, no one's getting it back from me until I retire. So I won't be giving it up. I've thought about an inspiring person in my life, and I certainly have grandparents that were amazing mentors to me. They were of the generation where if they worked, they were very restricted in what they could do. My Italian grandparents were the first generation American, so they were in similar ways told not to speak their language, not to show who they were culturally, and thankfully, in the privacy of our homes, we got those teachings. But if I reflect now, who has inspired me to stay in the work is the parents and families that are part of these cases, because I have never experienced such transformation, such awe of strength that I get to in a pretty regular basis in court. So that's who I would say is the inspiration that keeps me coming back. And if I didn't have this day of the week, I don't think I could do this job.
Thank you. That's so beautiful. Commissioner Porter.
My name is Robert Porter. I'm in Yakima. Yesterday was my 1-year anniversary on the bench. So a little bit of a lightweight compared to Commissioner Ressa. But I was a prosecutor doing domestic violence prosecution, late 90s, early 2000s. I adopted a number of children out of the system. And so I became a high school teacher for 16 years. Most of my children needed educational support, so it kind of dovetailed nicely into being able to be on their schedule as well as supporting them in their educational needs. And then the county prosecutor here took a huge risk on me, hired me to do juvenile prosecution, and then I made the jump to the bench fairly quickly. So I've always been involved in working with youth. I was in the Big Brother, Little Brother program. I worked through Boy Scout summer camps for a lot of years. I have done all the soccer programs. I have the soccer van, so not a lot of dads will confess to that, but I do have the soccer van. I think when I started domestic violence really was the tipping point for me. I did 3 trials, 3 days in a row. Actually in Spokane, Commissioner Ressa. I was on the DV grant team. And the first trial was about a man who would only hit his wife where the bathing suit covered her body. And the 16-year-old son got a baseball bat and went after his dad to protect his mom. And he was my state's witness. He sat with me. It was one of the hardest trials I've ever sat through. And I just had such great empathy for that family. As you know, the criminal case tore them apart. They ended up divorcing, but I know in the end what I did was for the best for that family. But it impacted me, and it still impacts me long term. And so I think that was the driver originally for my work with youth. But then definitely adopting children out of the system certainly kept me there. And that's been forefront. And my children now range from 14 to 28, and they are still suffering some of the effects of what they went through. But it's a constant reminder why we do this work. And I live it and work it and breathe it. So it's very personal for me.
Thank you so much. I appreciate that. And Bob, coming from a teaching background as well, so it's really fascinating. Thank you. Commissioner Stanley.
Good morning, everyone. I'm Elizabeth Stanley, and hearing Commissioner Ressa's story, I think I might be on track to follow in her footsteps, because I also took over this ICWA court in month 3 of operation, which is fascinating. Brandon Mack was the commissioner on the bench before me, and he did a lot of groundwork to get this court up and running. And then he was appointed to the bench in a neighboring county as a judge. And I took over from him after the court had only had 3 ICWA sessions. We have ICWA court once a month. So it's very much still new and in the process of getting the mechanics worked out. And it was honestly a great time to take over. And I think my background prepared me for this in some ways. And I think in other ways you couldn't be prepared for starting a court right when you're starting on the bench. I lived in the state of Arizona and worked at the Attorney General's office there for 5 years, doing exclusively dependency cases. I worked in Maricopa County, Arizona, which at the time had more kids in foster care, I think, than any other county in the nation. Arizona is a big state and only has 8 counties. So that's part of the numbers situation there. But it's also an area with a lot of ICWA practice. There is a very large Native American population in the city of Phoenix and also throughout the state. And so I really enjoyed that work, but I did not enjoy living in the desert. My husband and I were not cut out for the heat. And I had an opportunity to move to Washington and work for the Quileute tribe as a tribal attorney. So we moved up to the Olympic Peninsula, and I was a tribal attorney for the Quileute tribe for quite a few years. It was a great experience, and it was really interesting practicing both in tribal court and representing the tribe and the children in state court in various ways in various jurisdictions throughout the country. So between having been an AG and having been a tribal attorney, I had kind of seen it from both sides, or 2 of the many sides, I should say. And it's been really interesting now seeing it from the bench. And someone that really inspired me to do this work was one of the judges I practiced in front of in Arizona, Judge Lisa Daniel Flores, who is now retired, but she held everyone in her courtroom to a very high standard of excellence. And she would expect the most from everyone. And she never lost that sense of surprise when someone was unprepared. She never let people get away with it, and would just, she wasn't rude, she wasn't harsh, but she would say, oh, you must need more time. Oh, we must come back next week because clearly this is not how we would proceed on this case. And so she had inspired me to do better when I was in the courtroom, but also expect better from everyone. And I think that is what I'm trying to do with our ICWA bench, and I think is true for all ICWA courts, is that you're really looking for that gold standard as standard practice. So that was my journey to where we are today.
Oh, that's great. Coming from Arizona, that's wonderful. To our audience, I appreciate you guys using the chat. So if there's questions that you have, we'll definitely take those questions. So if you have any ideas, or you want to ask, you have an itching question that you want to ask the commissioners here, please put it in the chat. I know I kind of gave you guys an outline of what we were going to talk about, but I was going to skip because a lot of what you were talking about kind of really dovetails nicely to this question about what does cultural humility look like from the bench, and how does that influence like the word choice that you might use when working with parents. We do have some ICWA court studies out there, the baseline study, and I can even find it and throw it in the chat for the audience here. But in that, there's 2 key things that really showed some connection to practice. And so number 1, early tribal involvement. So how does that cultural humility really kind of build bridges to early tribal engagement? And then the second thing, and this is considered the most significant factor for reunification in ICWA courts, is mother engagement. And so how we're engaging with Native parents and families. And I know Commissioner Ressa, you talked about that's your inspiration, the parents that are before you. So how does that cultural humility build those bridges in the way that you talk and see the humanity of Native parents that are before you and Native children before you? So that's my question. If I go back to Commissioner Ressa, is that okay?
It's actually because of Sheldon on right with all my other quotes over here in my desk. It says humble leadership and change agent, because he's used those words in different settings where I've gotten the privilege to listen, to know that that is who I want to be. And that's not the teachings I received in judicial college. So it's hopefully coming around a little bit different in the last 2 decades, but that's not what I was taught. I think it's incredibly important for people to feel comfortable in your courtroom. And I don't know how to do that because I'm not the one whose family is in front of me getting their decisions made for them. So what I then have to practice is figuring out how to get feedback, which doesn't come very easily in my position because people don't want to approach you and tell you what you're doing incorrectly or what is offensive to them. So what that tells me is that I have to ask for it. I have to say, let me know if something happens. And if you're not comfortable telling me, then give people an option where to go. So we have what's called an FJCIP coordinator. So I can say, this is the person that if you want to give feedback to, you can be anonymous. But then at least I try to make myself approachable, and thankfully several of those folks are here. I have gotten feedback from the department about what it was like. I've gotten feedback from tribes about what it felt like. I learned a lot at that Denver conference about how to have a more curious and questioning tone instead of a confident tone, which is more what judicial officers are taught, even if you don't necessarily feel very confident, at least sound like you are. But I don't think that often lands on people as anything but arrogant. So I was specifically taught by, and it might have been Cassie, because I feel like she might have said something to me about learning a specific tribe's practice around elders and speech. And does somebody speak last in a hard conversation or in a decision-making conversation? And to not honor that in the courtroom could derail a case or make a family feel like they aren't welcome. And so that was a start of a practice of asking if there is a practice, and then maybe explaining why I might not be able to do that in that particular setting. But if at least I asked, I could say why I'm not doing it. The second thing I learned in Denver was that we have to do these in Washington ICWA inquiries to find out whether someone has any ancestry. And those are not questions that some people like answering. They're offended by them. They're ashamed by them. And to take some time to explain why I have to ask them, give them some time to step out, maybe talk to their lawyer, maybe decide they want to write it down and not testify about it. Because if someone has a lot of trauma around their history, a surprise at a shelter care, which is also a really hard hearing, might not be the best time to be having that conversation. And I'm working on how to best do that practice. Those are my two descriptions of humility. Sheldon, did you ask me another question that I didn't answer?
And you started that answer just about language, like how does that influence the way that you engage parents and engage people in your court?
I don't think, because even I don't like some of the statutory words that are used. I have to sometimes say things, then I'll have to say, this is what the law says I have to find, so I'm going to use that word, but this is what I mean. Or this is probably a better word to describe what I'm saying. The three of us talked yesterday about case plan and how a case sounds like a murder mystery, doesn't sound like a family. And so maybe a family plan or a family success plan are better words to use. We tried to go toward family time as a word for visits, but depending on who you ask, that's a pretty offensive term given what some people are actually doing. They're not having any family time. They're having a chaotic moment in a 6x6 room. So, but it's important to just talk to people in each particular hearing about the words you're choosing to use and why. And if you're not conscious of that, then you might not be aware of how your language is landing on people again. So you need to ask for that feedback.
Thank you. And I know I've taken from you, it's this idea around humble leadership. I think you really live that. So I appreciate you sharing that. Thank you.
I don't have to pretend to know what I don't know anymore. And that just came with probably some experience and confidence that it's okay not to know. I'm just telling folks that lawyers are not taught that, judicial officers are not taught that. We're supposed to, as if, be the knowing body, and we don't want to make you not feel confident that we don't know what we're doing, because we do know the law. But to be able to have a productive hearing with a family is not something you learn in law school.
Well, yeah. I think what you're talking about, like that curiosity, I think those are great guiding principles. Thank you. Commissioner Porter, same question to you. And we do have a question in the chat and we'll come back to that question. The same question to you about cultural humility and how that influences languages in your courtroom.
So I think, in all fairness, my court hasn't started yet. We just had our training on Monday and our first docket is set for the 15th. So we're very close to starting. So I'm very fresh in a lot of these conversations that you're asking about and Commissioner Ressa and Stanley are discussing. One of the things that I've struggled with is I'm a real straightforward white guy. And I'm trying to immerse myself in a native indigenous culture. And I don't know how to ask the right questions or even what questions I need to ask to get the right information I'm looking for to be effective. And so I had a really frank conversation with the Yakima Nation's chief prosecutor, Jessica Ramelsberg, and she was very nice about it. And she just said, it doesn't matter so much the words you choose as much as the manner in which you're asking those questions. And if you're coming across that you want to learn, that you want to be educated, and that you're trying to do the right thing, you will be received right. And so I kind of kept that as my guiding principle, that I'm educating myself. I'm learning how to do this so that I can be more effective in court. And as long as I phrase my questions right, even if I stumble and say an offensive thing, it's the heart behind the question. It's the effort behind the question to be better that's driving it. And I get some grace in that respect. And so the word in Yakima, I think, is Pushtin. So I'm the Pushtin asking the questions, trying to be the leader in the ICWA court. So I think that's real important to remember is in terms of cultural humility is educate yourself and approach the situation as one of education. And so when I'm talking with families, the family success plan really resonates because I think a lot of times we get sucked into looking at what services parents need and children come second. And I think children can be just as traumatized as parents can be with some of the things that are going on. And we have to keep that in the forefront. It's everybody. It's a family success plan that we need to focus on. Did I answer all your questions there?
Yeah, you definitely did. I think you
Okay.
really kind of brought to a fore as well, just kind of the nuanced difference between cultural competency and the cultural humility, like being knowledgeable about all culture, competent in all cultures is almost impossible, right? But being humble and being willing to listen and being curious, I think that's really powerful. So thank you for sharing that, Commissioner. Commissioner Stanley, same question to you.
Yeah, so kind of another way that this has come up for our court is our county has had a really long history of close coordination with the 4 tribes that are in our jurisdiction. And there has been historically held a couple of times a year just a roundtable meeting between the dependency commissioner and representatives from the 4 tribes in our county. And I have the advantage that I attended that as a representative of the Quileute tribe. But one thing I think is really key to that meeting having been successful is that it's not held in the courthouse and it's not held in the courtroom. Because however much you try to sit in a different format in the courtroom, especially now when people are in Zoom, someone always ends up on the bench messing with the sound or the computer. And no one else feels comfortable going up there. So a lot of times it ends up being, I end up sitting on the bench despite my best efforts. And it really just has a different tenor to the meeting. And so that meeting's coming around again. It hadn't happened for a while since I've been on the bench and things getting up and running. And we're having it at one of the tribes has a building that's only a couple of blocks from the courthouse, but I think having the meeting there really just changes the whole tenor of the meeting. And we really have it as a roundtable meeting where people can just bring their discussion items. I think a lot of the judicial leadership aspect that is important is doing what Commissioner Ressa mentioned, which is being open for feedback. And you have to very consciously create a space where that feedback can be given without people being self-conscious about that and having an opening to give it in a way that it doesn't have any ex parte issues or isn't case specific, but really just creating those spaces the time and just kind of the architecture that they can really happen.
Great. That's wonderful. There's a question there. I'll come back to you, Commissioner Stanley, and I think this is a really great question. So what are the resources that would be needed to meet the gold standard in ICWA court? ICWA, of course, has been called the gold standard of child welfare. And what are the expectations of a social worker to meet the gold standard? I know yesterday in the conversation that you were kind of doing prepping for this, I saw some of the notes that you guys shared with me is beyond just what the tribe said, so what's the documentation? What are some of those dynamics that you would like to see to meet that gold standard?
So I think more resources are always great. More services are always great, but no one expects you to pull additional service providers and resources out of a hat for a specific case. So we'll just put that out there first. The more resources you can come up with, the better. But that's not what we're looking for necessarily for the gold standards. What we're looking is that you properly utilized all of the resources that you have available to you and documented that. I know that really comes up a lot in our ICWA cases, that the court reports, don't fully describe everything that was actually done, don't create a clear chronology of services that were offered. And I know on our ICWA cases, we have many, many cases that more than one tribe is involved in. Families can be affiliated with multiple tribes. Parents and children can be enrolled in different tribes or enrolled in one tribe and eligible for enrollment in another. And the court reports really, the more specific they are, the easier it is to find that active efforts have been made and that gold standard is being met. Just saying the tribe agrees with the plan doesn't get me to where I need to be. What I need to know is which tribe you're talking about and who you spoke with at the tribe, and what that means that they agreed with the plan. So the tribal social worker's name you spoke with, or the tribal attorney, and they agreed with the plan with the following recommendations, or they liked this part of it, or they agreed with it but didn't like this part of it. Just the more specific detail you can have about those tribal interactions, the better. And that doesn't take any additional resource other than a couple of extra minutes documenting the work that's already being done.
Thank you. Commissioner Porter or Commissioner Ressa, do you have anything to include with that?
So we've had a lot of discussions about how we're going to address active efforts is what we're getting at, and how we're going to document that. The current prevailing opinion is it's always best to have live testimony in court regarding active efforts. But I think we've settled on a process where we're going to do an affidavit before every court hearing, 2 weeks out, where the social worker details what those efforts have been, including dates, names, places, those kinds of things. And then we'll give the parties a chance 1 week out from court to say, we need testimony regarding this. So it's documented, but also we have the mechanism to allow for some testimony to supplement or challenge some of the facts as the case may be. But I do echo Commissioner Stanley. It's did the social worker use all the resources available to the social worker, and how did those services or resources impact the family? Was it successful? Was it unsuccessful? If it was unsuccessful, why? What was the barrier? What was the reason? Is there an alternative service that we can now offer to readdress it? Because it's not a one-size-fits-all situation. It's always an individualized success plan, and what does this family need now? Not what did they need when the case started, what do they need now? Sometimes those needs change, sometimes those services change, sometimes those resources change. And so a social worker has to constantly assess the case and see what the current needs of the family are.
Great. I know the safety framework is a big practice up in Washington, and I do like the kind of critique on that is so parents could walk out knowing, why aren't my kids with me today? And what are the things I need to do to get my kids back? So being able to answer those two questions after each hearing and being very clear about that, I like what you're talking about, just as far as making sure we're really assessing that safety aspect all throughout the case. That's really important. Commissioner Ressa?
this is maybe where language for me is one of the most important things, is that I tend to use the language, the agency, instead of the social worker. Because I have a group of social workers that are the ones that appear each week in front of me. You start getting, because of downtime between hearings or court team meetings, you get to know some things personally about some of them. Sometimes they get to know me a little bit more. They're wonderful people and they do a thankless, very difficult job. So it's hard to say things in court that are likely to land as personal and offensive to the person that you like. It's not easy to do. But I don't think the law says it's up to this individual. It's up to the agency to do active efforts and the agency to provide the services. And I'm lucky to live in one of the bigger counties, so our resources are larger. And so I think that it'd be even harder if I was in a smaller community where the social workers that are in front of you are looking at you like, what do you want me to do? And then that's what I will answer. You have a supervisor, and you have a secretary. And so what I'm saying as far as what I expect to happen might be a conversation someone needs to have with Mr. Hunter, because the law is the law, regardless of what county you live in. And just because there isn't a service in a county doesn't mean that that service isn't the necessary one or isn't the active efforts. This is really tricky to do. And it could be why some people feel personally attacked. I have mentioned, I've given the feedback that the GJA decision that used the social worker name instead of the word agency, because if you notice, the court used the word court when it criticized what the court was doing. It didn't use names, but it used the social worker's name almost on every page of that decision. And I couldn't imagine, because I know her, what that would have been like. And we've got to do a better job, at least on that front. And I try to do it more in the courtroom of using the term agency so that the individuals know that it's not just you personal, but you personal need to be asking up that chain of command for that support, because it is the agency's job. And the agency won't know it needs to act unless it gets this information all the way up the chain. This could be because of my experience of representing the agency as well, that's who I talk to, is the people at those levels. If you go to a meeting with Olympia people, they'll tell you what great things the agency is doing. And then you can say, well, that's not trickling down to the line yet. And so how do we make that happen faster? But I also tell people, if you haven't read the 4 agreements, please do. And if you need to stand in front of the one that I always have to stand in front of myself, don't take anything personally. It is not about you. And I should never say anything that is personally attacking to you. If it lands on you that way, I'm telling you that's not the intention. The intention is that the agency hasn't done what I think it can do, maybe. And then you can educate me how I've gotten it wrong. That's also totally fine. But I just think there's a challenge in retention of social workers because of what it feels like in courts. And that's a way to at least discuss how it's not about an individual. But service letters, and I keep seeing that on the list of active efforts, I just go right by it. It's not an active effort to send a letter.
Thank you so much. I think you're right on. Beyond just the check the box kind of dynamics around the law, like how do we adaptively really think about this and feel about this and continue progress with the capital H humanity, like I feel like those are some big things that we need to be doing. I'll open this question. There's 2 questions in here that I'm going to kind of merge together. We're getting a lot of great questions in the chat. I don't know if you guys are following that. But the 2 questions that I'm going to merge together is number 1 from Angie. She asked, what are the educational requirements that judges and commissioners get in the state of Washington around ICWA? And then I'm going to bring in this really super smart question by Raina. It's about the Brackeen ruling. Of course, so we won 7-2. In the concurrence, of course, the equal protections issue with the 5th Amendment. So this is a con law question for you guys. But Kavanaugh in his concurrence, he raised the flag and said, oh yeah, you lack standing to bring this 5th Amendment challenge of ICWA being a race-based law. But if you sue judges, that might be the right type of standing. So any reflections on that and provide us some clarification around that and thoughts around that ruling. So those 2 questions, anybody that wants to answer.
So I'll start. Having come on the bench a year ago and having been in education and then a prosecutor for 10 months and then jumping to the bench, There was a high learning curve. And I went to judicial college, which was 7 days of training, but a lot of that was about how do you handle a courtroom, a brief overview of some subject matter. ICWA was not necessarily a topic by itself. And so when you take the bench, I came from a criminal background. And so I'm learning civil rules, I'm learning dependency rules, I'm learning ICWA rules, I'm learning case law. And these are a lot of things that I was aware were around, but they didn't impact my job assignment. And so they were not something that I was fluent in. And that doesn't happen overnight. So you have to have the humility as a judge to be able to say, I don't know the law here. What is the standard? And asking the parties in court or in their briefing to submit that to you and to help frame your discussion and how you need to educate yourself, but also not being afraid to ask questions that considers or that presents yourself as not the expert. I was told when I took the bench, I chuckled, I think it was Commissioner Ressa who said it, never admit that you're wrong. I was told that when I took the bench, and I understand why they told me that, but at the same time, I think I am much more confident when I admit that I don't know something. I need some framing, I need some background, and then allow the parties to educate me. And I also think I'm more accurate when I take that approach.
Mm-hmm.
So that's my input to the knowledge and education for a commissioner.
I don't think I threw Angie this softball, but I think she's probably heard this soapbox that I've been on about judicial education in the state of Washington. And a lot of states are similar, but some states have the blessing of family and probate courts or criminal courts that are just getting to focus on a specific area of the law, so they get training. So I know this because I teach it often. You get 90 minutes of dependency training at Judicial College within the first year that you take the bench. That is the only requirement you have for any other minutes of training in this area. That's it. We are required to get continuing judicial education credits. So you get to pick what those are after Judicial College. And my experience is many of the judicial officers that are assigned to this rotation, and when they're assigned to it, seek out the kinds of trainings that are going to help them on that particular docket. It's just not required of them. But my experience is people go find it. We do have an annual dependency training for judicial officers that AOC, Administrative Office of the Courts, puts on. Sheldon has spoken at it. We often have a heavy conversation around ICWA, given that we have so many reason to know cases in our courts. So it is an issue that's going to come up a lot. I guess it's to risk repeating myself, be able to say I don't know is difficult. And the complexity of that is you want people to have confidence in your courtroom that you know what you're doing. But it is way easier for me on a different day of the week to say, I don't know the probate law anymore about heirs and succession. So go and come back in 2 weeks with a brief, because 2 weeks for that case is not going to hurt somebody. It's going to just hopefully get a right legal answer. In our dependency cases, we need decisions now about whether children are removed or not removed, or whether children go home or don't go home. And so I don't mean to say that I know the answer to that. It's just very complex when you don't feel like you know what the standard is to apply to a factual scenario. Courts are only open so many days a week. I only have court once a week. If you have court only once a month, you can't keep just delaying the decision. And it's still an important thing to get it correct with the correct legal standard. Otherwise, we get case law that's not going to be helpful. The only thing I have to say, go ahead, Elizabeth.
I was going to say that's a good segue to that. How do we avoid being the Brackeen follow-up? I think. And so I was appointed to the bench in March of this year, so I have not yet attended Judicial College. So I got to go in January of this year. But luckily, due to my background, I had a lot of knowledge about dependency cases in ICWA coming in. I did not have that same knowledge about many of the other calendars that we're on. And I think that's something important to highlight, that we all also do many other types of cases, not simply dependency. So we are trying to keep up on many areas of law. And as folks who appear in our courtroom, I think you're hearing from all of us today that we would love to be more educated from all of you as well. If there's something that we consistently get wrong on the bench, use that court report and use your statements in court to clarify for us what we need to know, whether it's something as simple as an explanation of hair follicle testing or a bigger legal issue. You have our eyes and ears. And so please continue to educate us as much as you can. I think one good way to avoid being that follow-up to Rakeem is to avoid having cases with terrible facts in your courtroom. As judicial officers, we can't really change the law or close some of those loopholes that may exist in various ways, but we can avoid having shocking situations that will be really shocking when the public hears about them and will become a rallying cry. I think one way to do that is to make sure that we consistently apply ICWA from the early beginning of cases. So you don't come in with a ICWA placement after a child has been in a non-ICWA compliant placement for years at a time. Perhaps no one confirmed that no relative placements were available early in the case. And those are the kind of facts that have set up all of the cases, mostly that have made it to the Supreme Court over the last few years. So I think holding people to that high standard and early compliance with ICWA from the shelter care hearing is one way to avoid creating bad facts that lead to one of these cases.
I think it's incredibly important to ask those questions at the earliest possible hearing for ancestry. Most of the time, our social worker has that detailed in the petition already, but a lot of times in court, when you're having that conversation, well, I think I have black feet. Well, who in your family did you hear that from? Where did that come from? Oftentimes can lead to a specific name to go back and trace through a tribe, or it leads to a conversation. Well, my cousin told me, okay, can we talk to your cousin? Will your cousin know more information about this? And we can grab some of that earlier in the case, like Commissioner Stanley is saying.
And
That's great.
this is something we also talked about yesterday, is that this is also going to be important in more of our guardianship cases. Not just guardianships that come out of dependency cases, but also Title 11 guardianships, which we are definitely seeing more of in Clallam County over the last year. Just these private, and I don't know if it's related. I haven't to the fall in dependency filings that we're also seeing in Clallam County, but it is very difficult for parties who aren't represented to properly navigate these minor guardianship proceedings, especially ones that need to be held to an ICWA compliant standard. So that's something that's definitely been in our radar, and I think the other commissioners might have a bit to weigh in on that as well.
Well, this came up at our training on Monday. And so it's something we are going to have a conversation with all the judges about how we want to handle that, if we're going to put them on our ICWA docket, or if our minor guardianship docket will continue to handle them. My predecessor is now handling family law, Commissioner Silverthorne. So he's very knowledgeable. He would be competent to handle it, but we need to look longer term than just Commissioner Porter and Commissioner Silverthorne. But it's been raised for us. I think Commissioner Ressa probably has more experience with the topic though.
Well, it's probably been about 2 decades for those of you who are from Thurston County that I, as an assistant attorney general, and then Chris Wickham, then Judge Wickham as a commissioner, did a point counterpoint training about third-party custody and dependency. And what was positive about being an autonomous family that could go in and do their custody case without the department and without CPS in their lives versus having a dependency. And at the time, one of the biggest differences, of course, were that parents did not have lawyers in third-party custodies. So the change in our minor guardianship law over the last couple of years is that parents get lawyers if they cannot afford one in a Title 11 minor guardianship. The petitioner does not. So every time the grandma, the aunt, the adult sibling who's 19 comes into my courtroom and says, CPS told me to come and get this. And I say, where are they? They just told me to come and do this. And they're told, you can just go get guardianship of somebody else's child. It's not a low standard. And if the child has any ancestry, then that unrepresented grandma, aunt, 19-year-old sibling has then the burden of proof to show active efforts, get a QEW before they can ever finalize the guardianship. And that then becomes an impossible task, which then may relate to your data around disproportionality, because Native American children, Indigenous kids, are not going to be able to go that route that CPS wants, or maybe the family wants to do, because there's not that capacity. And the parents get lawyers. So, the minute those lawyers come on board, they're asking me to dismiss the case because the person doesn't even know how to give notice to the tribe. And it's creating a lot of drama and more trauma for families when they just get in a meeting, get told, if you don't go to court and get a guardianship, you're never going to get placement of this sibling because you have a criminal history. Or whatever, they always tell me this is what CPS says. I know that they're saying what they have heard, but it's consistent enough that it makes me worried about what families are being told and what the expectations of the department are, or maybe the misunderstandings of the department are about these guardianships. But they are increasing in every county.
That seems like they're increasing throughout the country. I was just in Nebraska. They're having a very similar issue in Nebraska. So there's the two part, I guess the latter part of that question that Raina asked about the Brackeen decision was, well, what can communities do? And Angel in the comment made a great comment about being lived experience. And it was kind of what you were talking about, Commissioner Ressa, is just about this is my basic way of explaining statutory interpretation. There's rights holders within laws, and there's responsibility holders within laws. And so you're kind of talking about how the agency as a whole are responsibility holders, and rights, and the tribes are rights holders within ICWA. So she had a question about how could families advocate and communities advocate where maybe the tribe does have a right to intervene, and maybe the tribe doesn't exercise that right to intervene on the ICWA case. And so what are some effective things that parents and communities could do to educate the public at large around ICWA? Maybe that's a question for you, Commissioner Stanley, because I know you worked for a tribe at one point. So
one thing I would say is that while the department has the duty to notify official channels at the tribe, families are also free to reach out through different channels that they have, whether that's through tribal TANF services, whether it's through the auntie at the tribe that actually is in charge of everything, that the department doesn't reach out to. And so just because through that official channel the tribe didn't intervene doesn't mean that the tribe won't intervene if they have more information from the family, I would say. So, and different tribes have very different approaches to this. Different tribes have very different resources available. Some tribes, for instance, always send attorneys to court. Some tribes send social workers to court. I know when I worked for the Quileute tribe, I wouldn't always be able to appear in courts in other states because I wasn't licensed in those states. And usually judges would give a lot of grace for those types of kind of more informal appearances on behalf of the tribe. But some of those, the notice would go to someone in the tribal office and not always necessarily be timely forwarded within the tribe. So I would just not take the fact that the tribe doesn't show up one day or formally intervene as a sign that no one in the tribe is willing to be engaged. So that's one way to advocate for yourself. I don't know if that's helpful.
that was great. I have to actually loop on the back of that. What is some, you get to see a lot of advocacy. And so what are some effective, and if I was a attorney representing the tribe, or if I was a social worker representing the tribe, what are some tips that you would give me if I appeared in your jurisdiction for effective advocacy? What are some things that you've seen that you'd say, you should do this, Sheldon?
I mean, for the tribe in the courtroom, or?
Yeah, or on the phone or on Zoom or.
Yeah. Well, what I ask tribes is, what do you want the court to know, or what do you want the other professional parties or the family to know about any child rearing practices or cultural practices that would be useful to us. Tell us what you want us to know or what we're not getting. I say things, I know it's not easy to be the person that's making the criticism in the room about active efforts, but do you see any concerns about active efforts? Or sometimes even the better framing of that, or what do you see as the active efforts here? So that I can learn from that perspective of the person from the tribe if this is active efforts. And to
I
go
would
back,
also say,
go ahead. Go ahead.
I would also say just filing something prior to court, even if it's just a one-page letter with bullet points, or also filing something with some attachments, especially tribes that aren't our local tribe. If you just have, you know, some basic handouts about your tribe that you use, filing with those with the court so I can review them ahead of a hearing is really helpful. You never know what's going to end up happening that day when you're in court. Another case might end up taking an hour and a half, and so everyone's, you know, just trying to squeeze your case in, and you won't have time to do that lengthy hearing unless we set it over to another day. But I will always read materials submitted to me prior to court. I do my best to thoroughly prepare for all of my cases. And then you can still do that oral advocacy in the courtroom, but you can just start with, did you have a chance to read the materials I submitted? So you know there's this basic level of knowledge I'll have going into the hearing.
I always read all of the declarations and documentation that have been filed. And so I think that's a great way to start the conversation off. Did you read it? Or I specifically tried to say at the start of every hearing, I have read, and then detail the declarations that I've read. And so that everybody's aware of what point of view I'm coming into the hearing with, and where they can pick up advocacy or factual arguments or information for the court. I think that's a really strong point, is being able to have that communication back and forth. So if we forget to say it, certainly ask us, but also I try to say it as much as I can.
Tribes, at least if they're in the confines of the borders of a state, should go to their state's law schools to make sure there's an Indian law class being taught. And I teach the juvenile law class at Gonzaga, so it was last night. We had our expert, she's a social worker, or she's a professor, former social worker at the University of Alaska, to tell us about her research on connectivity and addiction. It's nothing to do with any black letter law. She's not a lawyer, but it was our ICWA night. And so it was an hour of time where people are required to learn about the history of at least the Indian Child Welfare Act. So there's much more to Indian law than that. So tribes can make sure that the higher education institutions in the states are educating us.
That's great. My next question's about, and there's a great resource that Talina, I've shared in the, so her office is putting together some guiding questions, and it's kind of on the back of what Commissioner Porter was talking about, of asking everybody in the courtroom. You know, that inquiry goes to anybody in the courtroom could educate the court on Native American ancestry or heritage. And so there's going to be some resources for everybody available. My next question is really about data. And so like and I know even in the advertising of this panel, we talked about disproportionality in Washington. Nationwide, there's a ×3 disproportionality in data. And you were talking a little bit about guardianships might influence some of that. But what are some data that you use, or do you use data to inform practice as far as what needs to happen within your jurisdiction as far as getting it right? We're kind of learning a little bit that inquiry is a big area of practice that we need to make sure we get right. How do you get informed by that? Is there a data sheet that you look at, or is it mainly from practice and people before you, or how's that look?
Oh, I'm a little more at a disadvantage than Commissioner Ressa and Commissioner Stanley are. They both have FJCIP coordinators in their jurisdiction who do the data mining. We are in the process of hiring one, so we will have that resource next year. We are also compiling, or about to compile, our starting data so we can see the impact of our court. One of the pieces that we went to a ICWA conference in Arizona. Sheldon sponsored one day of it, and with the Pasqua, I can't remember the second word.
Yaqui.
Yahi, thank you. The Pasqua Yahi tribe. And one of the things they really sponsored or suggested was, as a result of your case, are more children being registered with their home tribes? And so I've been asking that question now. Have you done registration? Are the parents filling those forms out and asking social workers if that's something that's in the works? Social workers can't fill it out, is my understanding, but they can certainly help a parent fill it out to get it sent in. And so that's key. If it's okay, I was going to respond to 2 questions in the chat real quick.
Please.
So Ms. Ives asked, who do you learn this from, and what other questions? Oftentimes I will tell a parent, talk to your attorney, find out if there's another family member who knows information, bring that back to us. Tell your attorney, tell the social worker. They know how to tell the court. And so I will encourage parents to go home and have those conversations. But if somebody's in court, I can swear them in and ask them questions as well. Oftentimes parents come with support people, which are relatives who have some of that information. And so we try to grab it as we can. But then in regards to Amanda asked, should we file a letter even if it's a ditto? Absolutely, absolutely. That is a documentation that would be in the file. If the case ever went on appeal, the tribe's position would be absolutely recorded and memorialized, and it would be part of the written record that anybody who's reviewing the case would be able to see. Okay, I'll be quiet now and let the other 2 jump into the data discussion.
Thank you. That's great.
I know we're recording, so I'll be careful about what I will say about our data and what it means. I am not going to ever argue that disproportionately Black and brown children are in child welfare systems. They're in offender systems in ways that show we have racial practices in our systems. However, we also have reason to know in our state law, which expands the number of people who will be eligible for the application of ICWA earlier in a case, and that may change more often than it used to, for example. So I don't want to discount the number of kids, but I also want us to be careful about our data. Also, one thing our data shows is that Indigenous children spend longer in cases. But I, again, challenge the assumption that that's bad. We have cases that go on longer because they need to, because active efforts might take longer. We have these competing federal laws, ASFA and obviously ICWA, where you're supposed to do something in 12 months or 15 out of the last 22, and things that don't always make a lot of sense for the families. Tribes get 20 days to ask for a continuance after their notice on a termination matter. So if they come in and want a continuance, the court has a pretty high burden to say, no, you don't get a continuance. So that can also delay things. So just curious that we have complexities around data and how to interpret it. And I'm not sure that if there are multiple cultures for a child, how we're capturing that in the best way to fully understand who is in our system. I'm confident I can just say Indigenous kids are overrepresented, and that's not positive. But to the extent they're overrepresented, it's something we need to be talking about, because if we find out that ICWA doesn't apply, is that what we're measuring, or are we measuring something else? Just the fact that they have ancestry might be enough for our data. And then we have lots of county and state systems that don't work together and don't track the same. And so we have, in my opinion, the state agency with data, and we have AOC with data. And we have to do a better job in the communities and the regions of getting our local data to those places so that we're all comparing the same information, which I know we're better at than we've ever been. I just know there's still improvement to do.
I like that point that you're making, as far as, like, I think sometimes too much emphasis gets placed on the race to permanency. How quick do you get to permanency, rather than getting it right and meeting, like ICWA has a strong emphasis on making sure children are connected. And so I like this model that I threw in the chat there, you know, that we have children inside those circles, those concentric circles. So thank you for highlighting that. Commissioner Stanley, I know you're going to say something else.
Yes, I think that court data is really interesting. And what I would like to see is that compared also to other kind of data from after children enter the court system and after they leave, before and after they're in the court system. I know our county has had an absolutely unprecedented opioid outbreak. We have one of the highest overdose rates in the state. I understand that we also have a really high proportion of children being born substance exposed. And I would like to see how the changes in hospital statistics for exposed births correlate to filings in our state, if we're filing on more or less of those over time, or if they track each other. I'd also like to see, you know, studies of how children are coping years after leaving the court system, and even as adults, and to really use that data, I think would be great. I would love more data. And then I think both commissioners have really highlighted that it's a good starting point, but you shouldn't base all your decision making just on these quantitative factors. Each case is unique and there are qualitative factors to consider as well. It's pretty easy being in a smaller county. We have, I think, just under 100 children in care right now in our county. And so, you know, for instance, it'll show that we have 2 cases that we didn't get to fact finding within 90 days on. But I know off the top of my head, one, we were waiting for an interpreter of Polynesian language, and we just couldn't get one. So we had to send it out, and that was just for entering agreed orders. But we just had to get documents translated. And so I know that statistic doesn't mean we're failing to meet our timely, because that shows that's like, you know, 20% of our filings for this year have not complied with that fact finding within 90 days. But I know it was just because Clallam County had no access to a Polynesian interpreter. So data can be illuminating, but it can also, you know, not present a realistic picture. So it's just important that you use data wisely.
Well, and I think the thing I wanted to summarize there was the data we're collecting out of dependency is subjective. It's very subjective. And we're trying to turn it into, this is my former math teacher coming out, we're trying to turn it into objective data. And sometimes subjective does not become objective very well. I can tell you that my children came with racial identities when I adopted them. We did ancestry. 2 of them who have chosen to represent themselves as Hispanic, Latino, Mexican, actually came back as Sonoran Native American. And so, you know, the reliability of race classifications is only as good as family understandings are. And that you're taking very subjective conclusions and turning it into objective data. And we have to be careful to make sure that that data is correct and really represents what it says it's representing.
Good point. I know so some of the ICWA studies that we have as far as data outcomes, and I compare it to the metaphor that's often used with child welfare. You know, that we were down by a river. If we were out by a river, we saw children floating in a river, we'd have enough compassion, we'd have enough humanity, and engineer a way of getting children out of the river. But eventually would ask going upstream and why are children coming into the river in the first place? Kind of like what you were talking about, Commissioner Stanley, about like who are the ones referring, you know, and I know NCAN's data, there's a couple of ICWA jurisdictions that we're kind of looking at. Who are the partnerships that we need to build beyond CPS? Do we need to build a better law enforcement partnership? Do we need to build a better partnership with hospitals, you know? And so I really like that point. And the question that I wanted to wrap on this is, how do you remove barriers? And I know Commissioner Stanley, you were talking about working for a tribe and appearing in jurisdictions maybe where you're not licensed. Has Washington adopted a pro hoc rule for out-of-state attorneys to appear? Have you been pretty liberal as far as if an out-of-state social worker is going to appear or file documents in your jurisdiction? What are some ways that you remove those barriers of tribal participation, since we know that's a big data point, or the secret sauce, like I usually like to call it, of ICWA courts? What have you done to remove those barriers?
I'm not sure I have had a not Washington licensed attorney appear in court as an attorney. I don't think there's a legal barrier to, we have several Cherokee cases, several Navajo Nation cases, and there's no issue with social workers appearing in court or filing paperwork. All our court hearings are still on Zoom. So that's been great and made it really easy, I think, for them to appear, and I think is a little more reliable than when they would be on speakerphone in the past, which I had a lot of experiences, both as an AG in Arizona with trying to get folks on speakerphone and trying to appear in courtroom on speakerphone, which is difficult. So I think those Zoom appearances are good. And I think that may be just something I'll think to ask whenever there are out-of-state tribes that don't have regular local counsel. There are several, I know, Tlingit Haida has Washington counsel, some other larger tribes that appear often have local counsel, but just bring that up whenever there are out-of-state tribes, just add that to my practice of just checking in to see if they have tribal attorneys, and if so, they should reach out. I think that's a great thing.
Thank you.
I know we're not all grateful for all of the things of the pandemic, but I'm so grateful for the forcing of courts to address the technology problem that we were having statewide, and the ability to appear in our courts depending on where you were from, even if it's in another part of the state. So phone appearances are very inadequate for being able to understand if the person is understanding you, if they have a question, if they're hearing and what's happening. I'm absolutely guilty of, because the phone is over here to my left and I don't even see it, forgetting that somebody's even on the phone. Very, very different than when you can see somebody on a screen. It's helped tremendously to meet the voices that I've heard over the years. But I just want to caution people that there are still courts that don't allow Zoom appearance in dependency. Maybe I'll just say court. And then there are courts that are trying to remove the option. So likely it will be a 39 decision ability to appear remotely in going forward in our state. Some courts will continue to allow it, some courts will take it away altogether. And unless I'm wrong, one court still only allows phone appearance. If you think about it, especially given, so Elizabeth said there's 8 counties in Arizona. We have 39. I think Minnesota has 84 or 80. So depending on the state, and you're the Cherokee Nation, and you need to respond to all of them. And the idea of appearing and having lawyers definitely creates a barrier. So if anybody has a brilliant idea about how participation can happen that doesn't involve a time zone and a very specific, maybe an hour waiting for your 15-minute hearing, where tribes could participate in different ways, I'd love to explore those options and then give them out when we have new cases in our jurisdictions. Things like, if you submit something in writing, that's great, because then at least if you can't appear because I'm setting the hearing when it's 7 o'clock where you are and you don't work at 7 p.m., then at least I have something that we can at least have good discussions about in the reduction of those barriers. I think that there is not a way for me to explain to the tribes around me why I had to have court on Fridays in the year of 2023, because most of the tribes around me are closed on Fridays, at least their formal offices. So then I would either have to require them to participate on days that they don't work, or it was as if I was doing something to exclude them. And as much as I think I tried to explain that I didn't have the say about this, and I don't have to do it again for 7 more years, I'm still disappointed that I couldn't get it moved.
Great point. Then it looks like there's a straw poll happening in the chat about allowing more remote appearances. It's really popular, it looks like. So everybody agrees with you. So thanks for sharing that. Commissioner Porter.
Well, ICWA will remain hybrid, at least for dependency and juvenile cases. Our county seat is at the top of our county and the bottom of our county is an hour away. And so when you have families who don't have resources for cars or rides, and there is not really an effective bus system that goes all the way down the valley, it's as much for parents as it is for tribes to be able to zoom in and have a reaction and have an input and be able to see who we're talking to. And so I firmly believe that we'll continue to be hybrid, allowing those Zoom conferences and links.
I know there's been some other ICWA courts that have, like the tribes that appear most in their jurisdiction, they've reached out to them and says, can you share with us your tribal holidays? Kind of like in line with what you're saying as far as Fridays don't work for us as a tribe. And so I know I'm Northern Cheyenne, we have a holiday on our calendar that's not on everybody's calendar. It's the day we killed Custer. So like, forgot to brag about that at the opening. So, but yeah, see people clapping their hands. And so, yeah, that's our holiday. So you're not going to get anybody at work if you schedule a hearing on that day, you know, so it's like our Christmas and Thanksgiving all rolled into one. So, and then we have ceremonial holidays that are big too. So appreciate you guys being thoughtful about that. We're wrapping up, and I do want to leave you guys an opportunity to kind of give just some general thoughts to everybody. And if you do want a question or a guiding question, just some things that maybe if I was a judge or if I was a lawyer that's on this or a social worker, some things that that you've learned from best practices in your court that you wish could share. Maybe I don't have the power to start a ICWA court in my jurisdiction, but some things that maybe you could give some advice on. Or if you just want to talk to us and share some of your observations and leave some inspiring words for us, we'll definitely leave some space for you to do that. So Commissioner Ressa, can we start with you?
To go back to those of you who are pro remote option, please be vocal, because your bench is likely to be making a decision based on the whole Superior Court system, which includes a lot of cases where remote appearance might not be appropriate for or might not fit well. And so they may be making decisions because they don't know your perspective. So please share them. If you're in a community where there's only one commissioner and that's one voice for the dependency, to have the community behind that voice could be very powerful and necessary, because a blanket removal of remote options might really set us backwards. Those are discussions that are happening. It is such a blessing to have expertise in the room. So that's what an ICWA court provides for your community. It provides you to have the experience from the social workers, from the lawyers, from the judicial officer. There isn't a surprise that this case has ICWA applicability. There isn't a surprise that we have higher standards or higher burdens of proof. And it calms everyone down about the panic of not knowing those things when you can create a space for the expertise just to drive the cases. It's, to me, the most important reason to have it. And I share this sometimes, and again, we're recording and you guys can do with it what you will, is as a lawyer, I was mad when I learned that ICWA applied, because I had too much work, too many cases, and then late in the time frames when I'm supposed to be doing a trial. I was also young, so forgive me for my reaction, because it wasn't comfortable and I wasn't confident that I would know what to do or that I would know how to argue the case well for my client. Had I been surrounded with because I was comfortable with dependency cases, I was comfortable with the state law. So I felt very different. So once I reminded myself of the purpose of ICWA, got educated of the absolute need, even still, clearly still in 2023, for this reparation, it's incredibly important to have the expertise and the passion around this particular state and federal law. And we're lucky in our state to have a state law. It stops that confrontation of people's egos when they start to feel uncomfortable or vulnerable that they might not know something they think they should know. And then the last thing I'll say is perfection is poison. Please don't expect it of yourself or anyone else.
Thank you for sharing that and being vulnerable and talking about your growth. That's great. Thank you so much. Commissioner Porter.
So I made a couple of notes here. Yes, we would like our red dot on your map, please.
We'll get it up there.
Um,
I already sent it in, so we're waiting for it to be up there.
Wonderful. I do agree with Commissioner Ressa, having a different voice in the courtroom and a voice that I often consider to be the expert voice is very welcoming and very beneficial. And it does help us stay on the right path. Dependency cases in general now are very large cases with a lot of parties. If you get a family that comes in with 3 or 4 children, you have an attorney for mom, you have an attorney for dad, you theoretically could have an attorney for each of the children. It's possible to have a guardian ad litem. You've got a tribe or tribes intervening. You could have 8 or 10 different participating parties in a case. And oftentimes, we're advocating for who we represent. And so when a tribe is present and advocating for the best interests of the tribal child or the tribal parent, that's a welcome voice to a hearing when we're handling it in an ICWA court. Because a lot of times that's overlooked if it's not brought to the attention of the judicial officer, or a tag wasn't made or a box wasn't marked. So yeah, I certainly welcome the participation, even of just a social worker, but an attorney is even better if we can get one for a hearing. But I think social workers definitely contribute to the services and barriers conversation significantly. And I think that's a welcome addition to a hearing. I wanted to reiterate that documentation is key. And so if you did it, write it down. We had a hearing recently where the social worker had written some case notes, but hadn't written others. And so in the large scheme of things, we're kind of in a quandary about what weight do we give to what? And so the hearing's not over. I'm not going to answer that, but it was an issue that came up, and documentation would have solved that. Submission to the court would have solved that. In terms of how to start, I think that's something a lot of counties are playing with. I started with a conversation with our home tribe, Yakima Nation, and I went down to the prosecutor's office, Jessica Ramelsberg, and I said, would you be interested? And she said, well, we have a functioning dependency court. You won't have many of our cases. And we only had 6 of our, I think we were about 390 at that time, we're Yakima Nation. And I think we're down to 2 or 3 now. And so our ICWA court is designed with the participation and the support of the Yakima Nation, but we will not have many of their cases in our actual court, because the majority of Yakima Nation children who need to go to dependency are handled by a fully functioning tribal children's court. And so we're using the tribe as input on how to be culturally appropriate, because they're our home tribe and they're the ones that we are deferring to for guidance on cultural humility, on best practices. I have a good working relationship with the tribal judge in the children's court. We have a conference set up later today for a case that's bouncing between our courts. But I think starting with a tribal conversation, would you participate with us? Would you work on a work group with us to get this going? And so we started the conversation in March, and I want to highlight that by November, we have our court starting. So we were able to do this in 8 months. Casey family has been a huge supporter. They funded our training that we offered on Monday to put everybody on the baseline. We had great representation from the Yakima Nation, from the WICWA committee. We had social workers, we had attorneys, we had OPD, OCLA. It was really a cross section, and we were very pleased. We had 96 people register, which for a single county and a single tribe, I thought was an incredible showing. And it's really about being willing to engage people and being willing to have a work group committed to making it happen and bring those different voices together, because everybody brings something different to the table. And being able to hear all those voices, address their concerns, and formulate your practice based on the different perspectives is what will make you successful.
Awesome. Thank you, Commissioner Porter. I know they're telling me they're about ready to give us the shepherd's hook. So Commissioner Stanley, do you want to give us the parting shot, the final thought?
Yes, and it's basically that there's nothing magic about an ICWA court. It's a great community where the focus, it can be a laser focus on ICWA. We can really make sure everyone's in that right mindset for an entire docket of hearings, but the law is the same. The practices are the same, and everything we've talked about today can be applied in any case. It's not a special rule in ICWA courts that tribes can file written statements. It's not, nothing we've said here is something that cannot be applied in every dependency court in the state. So whether or not you have a dependency, a specific ICWA dependency court in your county, you can still apply all the practices that we've discussed today. Because a lot of us, whether you're a judicial officer or a social worker or an attorney, no one person can get an ICWA court going. But you don't need to get that ICWA court going to raise the level of practice for ICWA cases in your community.
That's great. Thank you so much. I wanted to say thank you, commissioners. I appreciate you guys taking the time out of your day, and appreciate you giving us some wisdom and some guidance. So thank you so much for your work, and appreciate what you guys are doing. So thank you. We'll go back to you, Talina.
Thank you, Sheldon. Thank you, Commissioner Stanley, Commissioner Ressa, Commissioner Porter. Thank you all for your judicial leadership, for demonstrating humble leadership, for also the partnership and great words and your great focus that you have. Especially thankful for your time today to be able to share your great work that's happening in Washington. I do know that there's a couple of other counties, areas in Washington that are wanting to follow your lead. And just as well, that the partnerships that we have on our end to be able to learn together. So with that, we do have a transition that we'll move into, where our 11 a.m. session will have a session A, which if you're interested in session A, Kate Fort, a tremendous victory, Holland v. Bracken, you can stay right here. And if you are planning to join session B, and again, Robin just put those in the chat as well, so thank you for that. If you're attending session B, you'll need to log off and join Gina Cooper for fentanyl and xylene trends and clinical impact. So with that, that closes our morning panel in session, and we'll look forward to seeing you here in the next couple of minutes in session A or B. Thank you all.